listen to me. You can't just come in and file an answer and say it's inaccurate information and then not file an answer to their motion for summary disposition. Everything's based upon the pleadings.
Correct, but I did not receive that. That's what I was telling you, Your Honor. I did not receive that. I would have filled it out because I filed an answer the first time. I wouldn't have just ignored it, but I did not receive any information.
Slow down.
That's why I didn't fill it out because I didn't receive anything.
Slow down. Jennifer, did we send her notice of it?
We did send her a notice to appear. The attorney's office submitted with the motion a proof of service that it was mailed to the Tara Lane address on April 14th.
I did not receive that.
But you have a proof of service saying you guys mailed it, right?
There is a proof of service that plaintiff's attorney mailed the motion on April 14th.
And I did not receive any information. I would have filled it out because I filled out my response the first time.
It's not a question of filling anything out. It's a question of responding to their motion, and they think you owe this debt.
And I did not receive it.
Ma'am, just listen to me. I still have not heard you state to me the basis for your denial of the debt. You're saying there's inaccurate information. What is the okay, now listen to my question. What is the basis for your statement that there's inaccurate information? Do you agree that you held the credit card?
No, I told them that they cannot prove to me that they have this, that they owe this, that I owe it to them. And that's what I was stating the first time.
You never had a credit card with a company that then assigned it to LBNV, to your knowledge?
No.
Who was this debt with initially, Ms. Olivier?
Credit One Bank.
You never had a credit card with Credit One Bank?
I have had a credit card with Credit One Bank, but what I'm stating, Your Honor, is they have not proven to me that the debt is owed to them. They have not given me proper information stating that they bought this debt from the original creditor. I have no original contract.
Well, I think they attached it. Did you not, Ms. Olivier, to your motion for summary disposition? I see you reference a bill of sale here.
Yes, it is attached, Your Honor. And just for the court's information, defendant does not have standing to argue about whether or not it was assigned. Only the parties in the agreement are the ones that have standing.
I'm going to go ahead and do this, Ms. Taylor. I'm going to adjourn the motion 2 weeks. I'm surprised you didn't receive it. I don't think the post office is that bad, but we're going to send you a copy of the motion now, and I would like your office to do it too, Ms. Olivier. Yes, nobody appeared. I'm sure we're going to just get some paperwork.
Your Honor, we did get a call. One of the offices said they were going to try to have someone log in. We finally got through to, but they didn't say that it's been settled on the phone.
But why are we having to be people's babysitter that are lawyers? Why are we having to do that? I just don't understand. Like I said before, we can't make it any easier for lawyers, right? I mean, they can log on from their boat, their country club, they can log on from their house, their office. They still can't get on without us calling them. Really? Wow. LBNV versus Sandal Taylor, 2504738.
Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
Good morning. Yes, Annie. Ms. Taylor, good morning to you. Your name?
Good morning, Sandal Taylor.
I thought, wait a minute. Okay, so this is your motion for summary disposition. Did you guys talk?
I attempted to this morning, but the defendant did not want to discuss anything.
You didn't file a response to their motion for summary disposition, did you, Ms. Taylor?
Yes.
Do we have that, Jennifer?
Judge, I'm double checking.
I did not receive anything, Your Honor.
You filed an answer to their motion, ma'am?
Yes, I did.
When did you file the answer to their motion?
I filed it. It was just 1 second here.
Talking about an answer to the complaint now.
Oh, answer to the complaint? I did not receive that.
No, wait a minute. Wait. I'm asking, did you file an answer to their motion for summary disposition?
I did not receive, the only response I gave to them was the
Ma'am, they
Richard
filed a
one.
motion for summary disposition that's up for up for today. They're asking me to enter a judgment in their behalf, saying that there's no genuine issue as to any material fact. Did you
Okay,
file
because
a response to that?
I didn't receive anything.
Well, why'd you show up today then?
Well, I showed up today to plead my case because I don't understand what this is coming from.
Why don't you go ahead and proceed with your motion, Ms. Olivia?
Thank you, Your Honor. In this case, Your Honor, plaintiff filed suit to collect the remaining balance due on a Credit One Bank credit card account. The defendant did file an answer saying inaccurate information and that this debt amount cannot be proven. Plaintiff did file its motion for summary disposition, stating that defendant did not present a valid defense to plaintiff's claims and that defendant's answer does not overcome plaintiff's pleadings and proofs, nor has defendant demonstrated that a different amount is owed. Thus, summary disposition under MCR 2.116C9 is proper because defendant failed to present a valid defense to plaintiff's claims. Further, summary disposition under MCR 2.116C10 is proper because plaintiff's evidence proffered clearly establishes defendant's liability such that no genuine issue of material fact exists and plaintiff is entitled to judgment as a matter of law. Plaintiff requests that its motion for summary disposition be granted and that judgment be entered for plaintiff and against defendant for the full amount paid for in plaintiff's complaint, that being damages of $980.04, costs of $111.02, statutory $20 attorney fee for a total judgment amount of $1,111.06.
You said statutory attorney fee of $20, I thought. You meant 75. What?
Because it's a motion, I thought that the statutory attorney fee was $20.
Well, you get a motion fee, you can collect a motion fee of the $20 plus your statutory attorney fee on a default on a judgment of 75. Am I missing something?
Okay, we can change it to 75. I don't have a problem with that.
Well, I mean, if you don't think you're entitled to it, I don't know. I just never heard that. And if you want me to just say you're entitled to the motion fee of 20 instead of statutory attorney fee of 75 and the motion fee, I have no issue.
I'll just keep it at the 20 because that's what my office already prepared.
Okay, good enough. Ms. Taylor, what is your defense here, ma'am?
My defense is that they have not given me a full purchase and a sale agreement for this debt. I did not receive that.
Ma'am, you needed to go ahead now.
Okay.
And you have
Your
to
Honor.
What?
I'm just looking, is it, I guess it doesn't have. There are 66 pages of attachments to this motion. Is Ms. Taylor able to come to the courthouse to pick it up versus us mailing it?
Can you
Larger
come and get
envelopes do take longer. That's the only reason I'm concerned.
Can you come and get that, Ms. Taylor?
Yes, I can.
And you just have her acknowledge receipt on something that's in the file, okay?
Okay.
How long will that take you guys to get that ready for, Jen?
I can have it ready in just a couple minutes.
So anytime you want to come this morning, that would be perfect, okay?
All right, sounds good. Thank you, Your Honor.
Wait a minute, we're going to adjourn the motion to July, what, the 13th?
Correct. I'm just looking up a time.
We can do 8:30, right?
Yeah, we should be okay at 8:30.
So, ma'am, we'll give it to you and then you have to file a written response, okay? I'm gonna give you the benefit of the doubt here that you didn't receive it,
Okay.
but you have to file a written response.
Okay.
Documentary evidence or other evidence, like an affidavit that says this isn't my card or I don't owe this debt. That's how you defend the motion for summary disposition, okay? You can't just come in verbally and say, hey, there's some inaccurate information.
Okay.
Okay?
But I'll make sure I pick it up. Thank you, Your Honor.
All right, have a good day. Thank you.
You too.
Do you still need my office to mail it to the defendant?
No, because we're
Okay.
going to give it to her. She's going to come over here and we're going to give it to her. You can leave your house whenever you want, ma'am, or however you're going to get here.
Okay. Thank you.
Thank you. LVNV Vite versus Hancock, 2600624. Why are you guys making us call your offices, guys? Come on.
I thought we had settled this. Can we go to a breakout room, Your Honor? I thought we had settled this.
I adjourned it to today at 8:30, but I don't know. There's this increasing number of lawyers we have to call, and I don't think that's our function. I didn't have judges call my office when I was practicing. I know things have changed. Actually, it's a lot easier. You guys can do these wherever you want. Go into a breakout room, see if you can resolve it. If you resolved it, if you didn't, we'll just go ahead and I'm going to have to set, I guess this is up for pretrial today, right, Jennifer?
It's up for a motion for summary disposition,
Oh,
Your Honor.
that's right. You guys want to go talk? That's right. I read it. Go ahead. You want to go talk?
Yeah, just for a second. Yeah, because maybe we didn't get it ready to send it, but we accepted that. Okay.
Is Mr. Galster out there yet, Jennifer? Regions Bank versus Renee Karras, 2600561. Regions Bank. Ms.
John?
Ozog.
Good morning, Your Honor. Andrew Cates, P78292 for Regions Bank.
Morning, Judge Attorney John Camilleri on behalf of the defendant, Renee Karras.
Oh, there you are. Okay. What are you guys doing on this? You going to resolve
ahead,
it? Or
Your Honor, at this point,
Judge, I think he's got some transmission issues. We're asking 60 days for discovery and come back after that.
all right, Mr. Case, can you hear me?
yes, Your Honor.
I'm going to go ahead and do that. This is what I'm doing. I'm giving you the same that I did before on these others. Let me see here. Give me 1 second. You're 78292, right? And Mr. Camilleri, 47348.
That's right.
Trying to get my eyes in focus here. What did I give him on the other ones? Should I give him August 28th discovery cutoff?
Yeah.
August 28th discovery cutoff. Witness was due July the 28th. I'm putting down 1/2 hour for trial. Nobody demanded a jury. We're not going to have a settlement conference. July 28th, witness was due. Again, discovery cutoff August 28th. You don't have to file a trial brief. If you choose to, you have to file and exchange it no later than 7 days before the trial date. Jennifer, what date did we give again? October what? 6th?
October 6th, 10:30.
10:30. Okay. So we'll send this out to you guys and you'll have it very shortly. All right? Yes.
Judge, do we got a cutoff for motions?
All motions have to be filed and heard not later than 20 days before the trial date.
Understood.
Okay. Thank you
Okay.
both. Have a great day.
You too,
Thank you,
Judge.
Your Honor.
Take care. Bye-bye.
All right. Mr. Galster, let me go back on that. Christian Financial Credit versus Austin Ortega. Mr. Ortega, start your video, please, and state your name.
Austin Ortega.
Counsel.
Thank you, Your Honor. We had a chance to speak, got a lot of information, and we would like to set a control date of 2 weeks out for Mr. Ortega to provide the documents to us.
So I'm just going to adjourn the creditor's exam to July the 13th, the continuation of the creditor's exam. And I'm just asking if you get everything. So you have to be here. I'm going to give you a date and time here momentarily, Mr. Ortega. It's going to be July the 13th, but we're going to give you the time of 9 o'clock in the morning. And if you get him everything and he conveys to you that he's satisfied, you guys can let us know and we'll cancel the court date. Otherwise, you have to be here July the 13th at 9. Okay?
Okay.
All right. Anything else, Mr. Gulfster?
No, will the corporate preparing a notice, or should we do that?
Say that again.
Will
We'll
the
mail
court
out a
be
notice,
issuing?
Judge.
Okay.
I didn't even.
Oh, he was asking if the court was going to mail out a notice.
Yeah, we'll
I will.
mail it out. Thanks.
Okay. Great.
Thank you.
Thank you very much, Your Honor. Thank you,
Thank
Mr.
you.
Ortega.
Thank you. Bye.
Second. All right. LVNV versus Hancock. 2600624. All right.
Good morning again, Your Honor.
Yes, I'm here. Yeah.
7884 appearing for LVNV.
I need you. You kind of cut out there, Mr. Nate. I need you to repeat your appearance.
So I'm so sorry. Preston Nate, P77884 appearing for LVNV.
Mr. Strauss?
P48673 on behalf of the defendant.
Any resolution?
We did. We got this worked out. We got a settlement and a payment plan that works fine. So I'll just need to get Mr. Strauss the consent judgment to sign and return, and then that should take care of this case.
Can we adjourn this to July the 13th with the understanding you'll have me everything before then?
That will be fine.
I'll adjourn the motion hearing to July 13th at 8:30. Just let us know if you would, please. If you resolve it and get the paperwork in here before then. Okay? Thanks, guys. Have a good day.
Great. Thanks a lot.
You too.
Appreciate
Thank
it.
you.
Thank you.
Velocity versus Kelly R. Shelley. 2600675. Your name, ma'am.
Kelly Shelley.
Counsel, your appearance. I don't know who's appearing. Is that you, Mr. Nate, on this one?
Good morning, Your Honor. Michael Bernstein, P69778 on behalf of Velocity Investments.
Okay. So I conducted a pretrial last time. And is there any, I'm honestly not sure. I don't have a motion in front of me unless, did you file a motion?
I may be able to resolve this for you, Your Honor. We've worked out a consent judgment. We just need to put the terms on the record.
Sure, go ahead.
Thank you, Your Honor. Damages in the amount of $17,476. Court costs in the amount of $233.80, plus the $75 statutory fee, for a total of $17,784.80 to be paid as follows. $291.28 to be paid on or before the 10th of July, and $291.28 to be paid on the 10th of every month thereafter until paid in full. Conditional dismissal. Excuse me. I don't know. I've been doing that all morning. Consent judgment to follow, Your Honor.
All right, ma'am. Do you understand and agree to those terms?
Yes, Your Honor.
So you agree that you owe $17,784.80, and you understand a judgment will enter in that amount, and that you have to pay $291.28 by the 10th of July and the 10th of every month thereafter until paid in full. So long as you do that, they cannot garnish your wages. They could garnish bank accounts, tax returns and the like, but they cannot garnish wages. Do you understand that?
Correct. Yes.
Your Honor, I just wanted to throw in there, she's our policy here, our practice is that if they're making the payment plan, we're not trying to do any of those other things either, so long as they stick to the deal.
So you understand what he just said, ma'am?
Yes.
Okay. Do you fully understand the contents of this?
Yes.
Does he have your permission to sign your name to this proposed consent judgment?
Yes.
All right. Any questions?
No, Your Honor.
All right, counsel, thank you very much. Consent judgment to follow. I wish you well, man. Good luck to you.
I have a question. You're in my file court?
Yes.
Okay, I just wanted to make sure we put it in the right place. Thank you very much. Have a happy holiday.
Same to you. Thank you. All right. Jefferson Capital versus Darren Thomas, 2505043.
Your Honor, I have plaintiff's counsel, Mr. Katz is here on that one, but I have not had defendant check in.
It was scheduled for 9:30, so I'm going to give him 15 more minutes. So, or 10 more minutes anyway. Citibank versus Daniel Trozen, and Daniel Trozen versus Citibank, 2600186. All right, everybody's name, please.
Thank you. Good morning, Your Honor. Daniel Best, P58501 on behalf of plaintiff Citibank, plaintiff/counter defendant.
Your name, sir?
Daniel Trozen.
All right. Did you guys talk and try to resolve this, Mr. Best?
We did, Your Honor. Defendant is working with a debt settlement company. We've had no communication with them. I walked Mr. Trozen through the process, and he has encouraged him to contact his debt settlement company to motivate them to get in touch with my firm. We have this one, and the court also has Capital One versus Mr. Trozen.
So, how do I say this? I'm not a big fan of debt settlement companies, but it's fine. You hired one. I get it. That's fine. But I'm going to go forward with the motions on this. If there's no resolution within 3 weeks, we're going to adjourn this to July the 20th, Jennifer?
27th?
Am I not doing civil on the 20th?
No, Your Honor, you have probation and department reps.
Your Honor?
Yeah.
Yeah, Dan Trozen. My wife on the 27th is having surgery and everything at 8:20 and everything.
Jennifer, let's set it for a week before.
Okay, we can. Do you want it first thing in the morning?
The 20th?
Yeah.
Yeah, I can do that. July 20th at 8:30, sir.
Okay.
So
And Your Honor,
call
just so you know, Mr. Trozen mentioned that he's not available on the 27th. That is the date currently for the bench trial. So if it doesn't resolve on the 20th, we'll need to adjourn the trial.
All right, I don't have a problem. I mean, we're not going to adjourn it a long time if it's not resolved, though, okay? And I wish you well, sir, with your wife's surgery. We'll adjourn this to July the 20th at 8:30. You're going to have to get with the debt settlement company, have them contact Mr. Best or his office and see if they can resolve it. If not, I'm going to need an answer to your motion for summary disposition. Okay, sir?
Yeah. Thank you very much. Yeah.
Hold on. Are we going to do the same thing for the Capital One versus Mr. Trozen?
That's not up for a motion, though. That's just
it is, Your Honor. They were both up for SDs today.
Oh, I yearn for the days when M-File wasn't here, Mr. Best. I'll adjourn this. I'm going to make sure you get those for me. Will you please, Sadie? Adjourn motion hearing to July the 20th at 8:30. So you're going to have to file a response on that. So please call your credit company, your debt settlement company, and have them get with Mr. Best's office. Okay, sir?
Yes, I will. Thank you very much.
I wish you well. Good luck to you, sir. Thank you.
Thank you very much.
Have a good day, everyone.
You too.
Thank you. Bye now.
All right. Do I have anybody here for Darren Thomas? Is Darren Thomas here?
No, Your Honor. I've not had him check in.
All right. What else do I have? I've just got Jefferson. The only ones I've got left up here are credit acceptance versus Cindy and Matthew Kornacki. Are they here? 2601583.
Both parties are in a breakout room on that one.
Good.
Yeah, read and start in the courtroom. Those enough 30.
And Mr. Katz, you're here on Darren Thomas, correct?
That is correct.
Okay.
You have that by chance?
The Jefferson Capital versus Thomas.
I don't have it.
About a month or stuff.
Well, I have Jefferson Capital versus Thomas, and I have credit acceptance versus Kornacki. Oh,
Yes,
Sean
those are the
Reed,
last two.
David- I'm sorry, that got stuck at the bottom here.
Right to the podium there.
Sean Reed versus David Lyle Stark. 2601964.
Right to the podium. No falls? Yeah.
Yeah. Your name, ma'am?
Sean Reed.
Sir, your name?
David Stark?
Are you licensed?
No, but I worked for a licensed surveyor. That job was done by a surveying company that I was the crew chief for.
Why don't you guys go out and talk about this, okay?
We're done.
I think that, yes, I'm willing to do
You want
that.
to?
Sure.
Yeah, you guys go out and talk and then come on back in. And I should have the rest of this out of here.
Here you go.
All right, so we had Jefferson Capital versus Thomas in a breakout, or Kornacki versus credit acceptance in a breakout, and nobody showed on Jefferson Capital versus Thomas, right?
No, Mr. Katz is here for Jefferson Capital.
Okay.
Mr. Thomas did not appear.
I'm going to wait about 2 minutes. If the defendant isn't here, Mr. Truba, I'm going to go ahead and give you a default judgment, so just bear with me. It's about 9:42. I give them all 15 minutes, okay?
Understood, Your Honor.
And service fees of $72.93. However, the defendants agree to pay and plaintiff agrees to accept a reduced amount of $1,698.11 to settle the account in full, provided that it's paid on or before September 27th of 2026. And then.
So they have to pay by the 26th, and if they do, you're giving them quite a discount, right?
They're paying 20% of the principal. They got to pay by September 27th of this year. Yeah.
And if they pay that, it's over. The judgment's deemed set, or the conditional dismissal will remain in full force and effect.
That's right, Judge.
And if they don't pay, then you're going to file an affidavit of noncompliance, and they're going to end up with a judgment amount of $86.61. Was it 35?
Yes.
Wow, you guys should have been lawyers. If
Credit
I get a
accepted.
credit card debt, I might have you negotiate for me. Listen, you understand what a deal this is? I don't see this happen. Do you understand, Ms. Kornacki, that he's telling me you owe $8,661.35, but if you pay all of it, the reduced amount, $1698.11, that the conditional dismissal will remain in full force and effect, provided you pay it by the 26th of September. If you don't pay that amount in full, he's going to provide documentation, and then the amount that you pay will come off this will convert to a judgment of $86.61.35, less whatever amount you paid between now and September the 26th. Do you understand that, Ms. Kornacki?
Yes.
Mr. Kornacki?
Yes.
Do you agree to those terms, ma'am?
Yes.
Sir?
Yes.
And does Mr. Mullally have your permission to sign your name to this proposed conditional dismissal, Ms. Kornacki?
Yes, he does.
Mr. Kornacki?
Yes.
Okay, do you have any questions at all, ma'am?
Nope, I am good.
Sir?
I'm good.
I wish you both well. Good luck to you. Thanks, Mr. Mullally. I await your paperwork. Thank you.
Yep, I'll submit it electronically. Thanks, Judge. You guys have a
Thank you very much. Jefferson Capital versus Darren Thomas, 2505043. Mr. Mullally, Mr. Cates, your name?
Andrew Cates, P78292 for Jefferson Capital this morning.
Unless the defendant has appeared, Darren Thomas, I don't see him on there. It's been 17 minutes, scheduled for 9:30, and it's now 9:47. You can go ahead and take your default.
Thank you, Your Honor. There are damages in this case of $1,400.87. Court costs and service fees.
Hang on one second. Hang on. Go tell them to keep it down to a low roar out there. I got small claims litigants in the vestibule area, and I mean, I feel like I'm at a baseball game, and the Tigers are winning, and they're in the World Series. Go ahead. Give me the breakdown on it. You got $1,487, you said?
$1,400.87 in damages, $142.47 in court costs and service fees, $75 statutory attorney fee, for a total of $1,626.34.
Default judgment, defendant failed to appear. 1626.34 is the total amount. You can submit your payment. Thank you very much. I mean,
Thank you,
your judgment, rather. I'm sorry. Thank you. Have a good day.
You as well, sir.
Bye now.
Probably 1% of people, 99% of people use this converter.
What's the problem? Well, what are you getting upset about? What time's your case?
10:30.
Okay. Well, we'll handle the case at 10:30. If the other party gets to it before then, I'll be glad to handle it early. Okay. Do we have any other 10 o'clocks?
We have one advantage, one case at 10 o'clock.
Didn't sound like you resolved it.
Oh, things are down.
You can go off the record. Sam, can you hold on to these? Yeah. Thank you. All right, I get up until something else is ready. Stay seated, okay? I can go to these. What's a little sore? gonna, Mr. Gulster, I'll give you your choice. I can either swear him in, put you guys in a breakout room and let you conduct that. Or I can adjourn it and have him send you all these items before then.
If you wouldn't mind, Your Honor, I'd like to go to the breakout room, maybe get some preliminary information, and then you can send the documents a couple weeks out.
So here's what we'll do, Mr. Ortega. I'm going to swear you to an oath. We're going to put you in a breakout room. You have to answer his questions truthfully and completely. And then if he has a need to get all those documents, we'll adjourn the remainder of the creditor's exam to a later date so you can gather all those and send them to him in the interim. Do you understand what I just said?
Yes, I understand.
Okay, I'm going to ask you to raise your right hand, please. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes.
Okay, well, why don't you go ahead and put them in a breakout room, if you would, please, Jennifer.
They are in, Your Honor.
All right, just let me make a note. All right. Geez. It's hot in here. What do you got it at?
It's like 70.
Well, let's turn it down. My eyeglasses are fogging up. Jeez. Warm.
Yeah.
So. You got a coat? You want to put on one of my robes? All right. Christian, let's see. Zeal Credit versus Emily Grifford, 2505093.
Yes, good morning, Your Honor. Clarence Kennedy, P88082 on behalf of plaintiff.
Good morning.
Your Honor, I've not had defendant check in with me.
Well, I gave her 15 minutes. I adjourned this from June 1st until today. I can't read my own writing. It looks like I said, I don't know.
If I could help, Your Honor.
Yeah.
Yeah, at the last pretrial, Ms. Griffer had her son appear as her guardian, her appointed guardian, and you adjourned it for him to get counsel because obviously you can't appear for your ward. And so I guess he probably didn't get counsel. I did reach out to him based on the contact information he gave me at the last pretrial, and I received no response.
Yeah, so I'm going to go ahead and give you a default. You can go ahead and proceed. Tell me the principal amount and we'll go from there.
Yes, Your Honor. So the damages owed on this retail installment contract are $4,883.46. Court costs of $246.72. The $75 statutory attorney fee for a total judgment amount of $5,205.18. There is judgment interest that's been accruing since we filed at 9.9%. That's the same as contract rate, and it's accrued $256.96.
Good enough. Default judgment is entered. Defendant failed to appear. Judgment will enter in the total sum of $5,205.18. I'll just ask that you forward that on to us if you would, please.
Will do. Of course, Your Honor.
For the record, it's 8:58 and the case was scheduled for 8:30. Granite Televalley versus Ronald Allen Bodges, 2600001.
Good morning, Your Honor. Daniel Landman, P35797, appearing on behalf of the plaintiff.
I think, Jennifer, last time I concluded that he was in custody. Is that true or false? Do you remember? And I told him on June 8th to appear in person, or defendant to appear in person. I don't know if he was here. I think he was in custody still.
Your Honor, I was asking Lisa to look it up. That's why I didn't answer. And she did say that it looks like he's in custody, but it shows the booking date from like November when he was originally. Yeah, but it does show him as in custody at the county.
Do you know if he has had his trial date? Ask Lisa to join, please.
Your Honor, our belief at the last scheduled date was that he was in custody, perhaps for violating bond conditions.
I think so. I think that's what I recall. And so you understand, though, I cannot terminate the tenancy while he's got a criminal case pending. I just do not feel comfortable. So I'm going to find out. For some reason, I thought his trial date was coming up in July, but that's a guess. So I'm going to
The
have
date that we're seeing on the county looks like there's a court date scheduled that's upcoming in August, but there's no other date until August 19th in the county system.
Is Lisa coming on, Jennifer?
I'm actually at her desk, Judge, because she was on the phone. So
okay, no problem. So I can't give you a judgment. So I mean, to me, rather than you guys having to appear, I can. Boy, this is looking bad for me. This case is going on forever, isn't it? Landlord tenant, how many am I supposed to have those done within? That's all right.
I think 56 days-ish. I understand the court's position.
I'm just kidding.
Yeah, the court knows our position as well. I think at some point there was supposed to have been a competency evaluation. I don't know the outcome of that. I don't know whether it even was held, because if he's in custody for violating bond conditions, it may not have taken place.
It still should have. I didn't violate his bond. That would have been after the bind over. If he had a competency exam scheduled, I'd be surprised if they didn't arrange for that to occur.
I think the competency exam was supposed to have been either in May or earlier this month.
Is Lisa still on the phone, Jennifer?
yes, Judge.
Why don't you bear with me?
I can go into Third Circuit's website and see what I
Why
can
don't
find.
you do that? And I'm going to go on to another case here for a couple of minutes, okay? And we'll try to figure out as much as you can. Geo Credit Union versus Hannah Holiday, 2600282.
Yes, Your Honor. Clarence Kennedy, P 88082, on behalf of plaintiff.
And good morning, Your Honor. Matthew Langston, P 7983, appearing on behalf of the defendant.
What are we doing on this one?
Yes, Your Honor. We just need a scheduling order, say 60 days discovery. I work with Mr. Langston. Excuse me. I work with Mr. Langston's office often, so I do believe we'll come to a resolution before then.
Okay. Just give me 1 second. Writing down P numbers here. You got 79838.
838, Your Honor. Yes.
Langston?
That's correct.
What is this kind of, what is this, just a credit card or what?
Credit card and an account agreement.
Yes.
Here's what I'm going to do. I'm going to make recovery cutoff will be August the 28th. I'll have you file witness list by July the 28th. Nobody demanded a jury. We're not going to do ADR. We're not going to have a settlement conference. You do not have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. And Jennifer, I'm thinking we set the trial.
October 6th?
That's perfect.
At 10:30?
October 6th at 10:30. Okay, anything else, gentlemen?
That sounds good, Your Honor.
Have a great day.
Nothing
Thank
else.
you.
I do have one more matter with you, Your Honor.
Okay. Sadie, you can say that. All right. LVNV versus Brian Hancock. Do I have LVNV here?
No, Your Honor, I have not had either party appear on that one, and I have not had the opportunity to call.
Mr. Neat, not Mr. Groom, Mr. Fay, Mr. Price, none of them?
No, Your Honor.
We adjourned it until today at 8:30.
I double checked to make sure that there wasn't any settlement paperwork filed this morning, and there has not been.
So I got no lawyer here, and it's scheduled for this. I'll put it aside for 20 minutes. If not, I'm just going to go ahead. If they're not here, I'm going to assume that they settled it. Velocity versus Thomas Ludke, 2601367.
Good morning, Your Honor. Angelina Abufarha, P number 88197 on behalf of Plaintiff Velocity.
Good morning. Do I have Mr. Ludke here?
Yes, I think he's stuck in our breakout room. I'm unsure if he knew how to leave or not.
I am messaging him to come out right now. Sorry, Judge. And when you're done, I did pull up Third Circuit so we can go back on Bologis.
Okay. Mr. Ludke, your name, sir?
Thomas Ludke.
Good morning. Ms. Abufara, did you guys reach a resolution?
Yes, we did. And I can put the terms on the record as well.
Please do so. Thank you.
Of course. So the total amount that is going to be paid is going to be $2,700. That's going to be paid over 20 months, and each monthly payment is going to be $135. I forgot to get the start date. So, Mr. Ludke, when would you like to begin this?
We can begin as soon as possible.
Okay.
Can you begin by July the 10th and the 10th of every month thereafter?
Yes, Your Honor.
Okay. Do you agree to those terms?
I do.
And is this going to be in the form of a consent judgment, counsel?
Yes, Your Honor.
So that's what we'll do. We'll have that, and each payment will be $135, beginning on the 10th of July and the 10th of every month thereafter at the rate of $135 per month. Is there any provision? Obviously, if he defaults, you can go ahead and utilize collection remedies, but is there any increase, I should say, in the amount of the judgment, or is it going to remain at $2,700?
It'll remain $2,700.
Okay. All right. And you understand and agree to that, right, Mr. Ludke?
I do, yes.
Do you have any questions for me at all?
No, Your Honor.
Okay. I wish you well. Thank you very much. Have a good day.
You too. Thank you.
Thank you, Your Honor. You as well.
All right. Let's go back on Granite Tella Valley versus Bodges, 2600001.
Once again, Your Honor, Daniel Landsman appearing on behalf of the plaintiff.
And Your Honor, if I may, starting May 15th on the Third Circuit's Register of Actions online, it is showing that there was a competency hearing, that the parties were present, and the result was continued. May 15th, it says order for criminal responsibility signed and filed. May 15th, the hearing granted, order signed, and then the jury trial was canceled and a competency hearing was scheduled again for August 19th.
And he's still in custody.
He's still in custody. It doesn't say whether he was deemed incompetent
Well, it sounds like
it just says order for criminal responsibility signed and filed.
Can we do this? Why don't we have him writ it out at least for another scheduled hearing next week or the week thereafter? We'll do it for the week thereafter. And at least we can send writ paper over there and have him appear by Zoom. Okay. And I can talk to him. He is not represented in this, but I cannot keep going on and on with this case either. But by the same token, he has Fifth Amendment rights that I don't want to impinge upon. So I think that's the best way I'll put it, unless you have another idea, Mr. Lanyon. I mean,
I'm okay with that, Your Honor.
Can I ask you a question?
Of course.
I know, but I'm thinking out loud how to phrase it. Would you consider dismissing this without prejudice and
Your
starting?
Honor, the problem with that is we would have to file a new 30-day notice.
Yeah, I know.
Serve him, and we don't want to do that, especially if he's in custody.
I just can't keep letting this go on and on and on. I'm trying to figure out a way, and I don't have a good answer for you. Because, I mean, I suppose you could be, technically at this point, you need his permission, as you noted, to dismiss the case. I have a feeling they're not even going to go in August. We're going to be doing this in October or November or December. That's the problem. Did you guys, what did you do with it? Didn't you have a non-payment or rent on this too? Did he pay his rent? Can you tell me, assistant manager, tell me your name, please unmute, tell me your name.
My name is Angela Cosa.
Yeah, tell me, did he pay his rent?
He did pay his rent, yes. His sister paid because he's in custody. I mean, I don't know. Nobody else has been in touch with us, so I don't know if they're going to continue, but she did come in and pay it last June.
Supposed to have I'm not really worried about going on report. I'm already on report on this, but it is getting a little bit. All right, look, here's what I'll do. Adjourn it 2 weeks. I'll try to figure something else out, but I don't have any answers on this one. I got to be honest with you. We'll adjourn it 2 weeks and have him read it out. Will you have?
Yes, Your Honor.
And we'll
do the 13th at 8:30.
Good with you, Mr. Landman?
Sounds great, Your Honor.
Thank you both. July 13th at 8:30. Have a great day. Stay cool.
You as well.
Thank you.
Portfolio Recovery versus Tracy Kelly, 2601597.
Good morning, Your Honor. Elise Carnegie on behalf of Portfolio Recovery, P79453.
Mr. Langston?
Yes, good morning again, Your Honor. Matthew Langston, P7983, appearing on behalf of the defendant.
What are we doing on this one?
We have a stipulated dismissal with installment payments, and I filed it about 20 minutes ago via my file. So it might not be through your system yet, but we have it signed by both parties. I'm happy to put the terms on the record.
Sure, go ahead.
All right, beginning on May 31st, the defendant will pay $36.62 per month.
Beginning May 31?
May 31st of 2026, the first payment.
Yeah, you know what? Can I ask you guys something? Am I the only judge questioning this? Why am I signing something that retroactively orders somebody to pay? I get that you guys reach these agreements, but I'm asking you to not do that in the future. I feel foolish ordering somebody to start paying something 4 weeks ago. He may very well have done that. I'm sure he did. But
I apologize, Your Honor.
No, you don't have to apologize about anything. That's not it. I'm not asking for an apology. I just think that when he makes that payment, I would prefer if he made the payment that you guys figure it out going forward. In other words, he made the payment, so there's a balance of whatever it is, $3,112. And then you put that down with your costs. I'm seeing this more and more. I've not seen it before.
Your Honor, I think it happens because the parties want to memorialize the entire agreement that we've had. And oftentimes those agreements get made pretty early in the process before, court dates have been set. And obviously, if that's your preference, I don't have any issue just adjusting the balance going forward. But I'm just explaining that's I think how it ends up happening.
Well, go ahead and do it this time. I don't need to hear your terms. You just submit it, but I'm asking you in the future, if you're going to have an enter into an agreement as an example, have indicating somebody's going to pay so-and-so on May 31. I'm just going to ask you to submit that paperwork to me before May 31 or deduct that amount and have the next payment June 30th or July 1st or whatever the terms are. So, but that's fine. I'm not, you don't need to think I'm scolding you, Ms. Carnegie. There's no reason for you to apologize, okay? Just, okay. I'll ask you to send the paperwork over and I'll go ahead and sign it this time, all right?
Thank you, Your Honor.
Thank you
both. Have a great day.
You too.
New Year's staff as well. Thanks, Lisa.
LVNV versus Brian Hancock. Is anybody here? All right, so I had motions on this. Nobody showed. It was scheduled for 8:30. Case dismissed.
Sometimes the hardest thing for a judge isn't deciding whether someone broke the rules. It's deciding whether that person deserves one more chance. This courtroom hearing began with a defendant who openly admitted violating one of the court's most important orders, a strict no-contact order. The defendant acknowledged that he had called his former partner several times, even though the court had specifically ordered him not to contact her. When the judge asked why he ignored that order, the defendant struggled to explain himself. He admitted there was no good reason. He simply reached out, hoping to talk, hoping to apologize, and hoping to have one final conversation. But the judge reminded everyone in the courtroom that a court order isn't a suggestion. Once a no-contact order is issued, it must be followed, no matter how good someone's intentions may seem. The protected person then spoke directly to the court. She confirmed that the defendant had left 3 separate voicemails. According to her testimony, one message asked to have a normal conversation, another complained about her family looking at his social media, and another apologized while acknowledging she had moved on with someone else. She admitted there were no direct threats in the messages, but she also explained that she had repeatedly asked him to leave her alone. The probation officer confirmed that the phone records matched exactly what had been reported, and that every voicemail came from the defendant's phone number. Although the defense emphasized that there were no new crimes or acts of violence connected to the calls, the judge made it clear that repeatedly violating a no-contact order is serious because it shows a willingness to ignore the court itself. Then something unexpected happened. Instead of demanding jail time, the protected person told the judge that she believed the defendant's biggest problem wasn't anger, it was his mental health. She said she wasn't convinced that jail would solve anything and encouraged him to complete the impulse control class that had been.
Can someone deserve a second chance, even after being accused of threatening to kill the mother of their own child? That was the difficult question facing the judge in this emotional courtroom hearing. The defendant was already on pretrial diversion, a program designed to help people avoid prison if they follow strict court rules. But prosecutors argued that he had thrown that opportunity away. According to the state, after separating from his former girlfriend, he repeatedly contacted her, despite protective orders being in place. The prosecution called the woman to testify by video, and although she appeared nervous, her testimony immediately changed the atmosphere inside the courtroom. She told the judge that after she sought protection from the court, the defendant continued contacting her. Then she described the moment that frightened her the most. According to her testimony, the defendant threatened to kill her if she didn't drop the criminal charges against him. As the hearing continued, the judge carefully questioned the witness about their relationship. She admitted they had lived together for about a year and shared a child. She also testified that the defendant had physically assaulted her in the past, and that many of the incidents happened when he was under the influence of drugs or alcohol. But then something unexpected happened. When the judge asked whether she was still afraid, sometimes the most powerful courtroom moments aren't about sending someone to jail. They're about giving someone one final chance to prove they can change. That's exactly what happened in this hearing. The defendant had already made mistakes, but instead of ending his probation, the judge decided to give him another opportunity. The judge explained that probation wasn't simply about checking boxes. It was about rebuilding a person's life. He ordered the defendant to continue working closely with the probation department, complete a professional evaluation, follow whatever treatment was recommended, attend a victim impact panel, and finish 32 hours of community service. The judge wanted him to understand that this wasn't punishment for the sake of punishment. Every requirement was designed to help him avoid making the same mistakes again. He reminded the defendant that probation officers and the county public defense team were there to help, not to watch him fail. If he had questions, needed directions, or wasn't sure what to do next, he needed to ask for help instead of falling behind. The judge then gave the defendant a clear deadline. By October 1st,